Hi, everybody. My name is Meredith Wallis. I'm a family defense attorney at Legal Services for Prisoners with Children. Thank you so much for joining us today.
Hi, and I'm Sharon Cartagena. I'm the directing attorney of the Child, Youth, and Family Project at Public Counsel. Um, so Meredith and I have worked together for a long time with some amazing other advocates on family integrity issues in California. And we started to hear the last couple months questions and a lot of fear around potential entry into foster care after families were impacted by deportation. We also, we work a lot on making sure that reunification is a real option. And we felt like reunification was a bit lacking from some of the conversations about family preparedness. So we came up with this presentation, and we're so glad to have you all join us today. To give you just a roadmap of what we're going to talk about, first, we're going to talk about what we mean by foster care and the differences between state foster care, which is CPS, or in Los Angeles County, DCFS, and federal foster care, which is ORR, um, and how to avoid any kind of foster care by making a plan, a temporary plan, and then your long-term plan with reunification as a potential goal, or with the child remaining in the United States. We're also going to, at the end, talk about what to think about if your children are also undocumented, because that adds a little bit of complication to your family preparedness plan. But I will pass to Meredith right now to answer the big question about if a parent is deported, where their kids go into foster care.
So, first, I wanted to start by saying that there are two current popular discourses circulating around what is happening and what should happen to children left behind when parents are detained or deported by ICE. The first one is based on a fear that children are languishing in state foster care. So you might see headlines like thousands of children stuck in foster care. And the solutions that are suggested put more onus on the Department of Homeland Security to honor parental rights. Out of this actually comes the current directives for what happens when ICE removes someone who is a caretaker for minors. You can see that in the handouts that you received that are specific to ICE. It's Directive 11064.4, and that describes the parental interests directive. The second strain of popular discourse is one which looks at the thousands of children in subpar conditions in the Office of Refugee Resettlement, which is ORR, as Sharon mentioned, and advocates that those children be routed through state foster care if no parent has made a plan, because state foster care, the logic goes, is better equipped to get those children quickly with family or even return to their parents than the federal ORR system. This is especially popular as a narrative in states where the child welfare system is considerably less conservative than the federal immigration one, or has even been one which has been actively helping children gain status, as California has. So the chart that you're looking at right now is sort of the answer to number one. But to sum up our talk, I will say that we have both a reinsurance as to the first issue, whether children are languishing in state foster care, which you see on the slide now, and a warning about the second one, which is what happens if we use state child welfare to solve the problem. So, starting with federal, this is the 2023 AFCAR numbers, which is the Adoption and Foster Care Analysis and Reporting System. This is current as to 2025, but it's the 2023 numbers. You can see that they began tracking a family circumstance for children who entered foster care and had a parent who was detained or deported. That number is, as you see, for percentage quite low. If you keep in mind that the entries for this year were 175,000. So it's lower than incarceration, disability, domestic violence, and significantly lower than the highest category, which is drug and alcohol abuse, which would be over 60,000 children. In 2023, just to put these numbers in context, there were over 300,000 children in foster care. And the highest number of those children come from California, which had more than 40,000 children in foster care that year, which is twice as much as the next highest state, which is Florida. If you're curious, the third highest is Illinois. So, to answer the big question, historically and currently, most children are not entering state foster care because of deportation or detainment. I'm going to give an overview of the federal system and then a more in depth explanation of California's state system so that we can answer the following, which is why aren't children entering the state system? And then why they shouldn't start. Next slide, please. So first, people often conflate the two terms. So sometimes you will see news articles that are claiming that children are in foster care, and it doesn't specify that they're actually in ORR custody. These are two distinct systems. State foster care is specifically and only to deal with child abuse and neglect, and federal is designed to deal with non-citizen children whose parents are not in the US or have not been located. Next slide. OOR custody includes both children who are in shelter care and ones who have been released to sponsors. Children who are put into ORR custody arrive there without investigations. They're not guaranteed lawyers. There's no court oversight or process to reunify other than getting to a host family or sponsor. So, this is, I think, part of why people think state foster care might be a better structure. And to be clear, the first 6 months of 2025 have included aggressive federal attempts to attack the previous structure of how children got out of ORR custody. This will result in more children in foster care, less releases to sponsors and parents, and more deportation of unaccompanied minors. Next slide. What is state-run foster care? State-run foster care is a county-run system of family policing. It's closely analogous to the criminal system. To trigger a California entry into foster care, the very first step, if you look at this diagram, is a call to the Child Abuse and Neglect Hotline. Most calls are made by mandated reporters. That means people in your state who are said they have to report child abuse and neglect or suspicions of child abuse and neglect. The top three reporters are law enforcement, schools, and medical social services. Basically, anyone that you would go to for help when you have children. Although rates for ICE as a mandated reporter are not kept, I would wager that calling the local child abuse and neglect hotline is very unlikely given ICE's own arrest procedure, which, if dealing with a parent who is currently with their child and has no plan, involves a choice between ICE calling local law enforcement or calling CPS, meaning calling the hotline to take custody of the child. The fastest way for ICE to offload a child is to call local law enforcement. So for that reason, my assumption is that local law enforcement is more often called than the child abuse hotline, because calling the child abuse hotline triggers this lengthier process, which there isn't an analogous process for local law enforcement. Once you call since most calls are from mandated reporters, if you have a population that is avoiding accessing services out of fear for deportation or is not allowed to access them because of their citizenship status, they will have less mandated reports generated, and therefore they will be less likely to enter the front end of the system. The next step is an investigation by CPS to determine whether it is more likely than not that the child has been abused or neglected. If it is more likely than not, and they call this substantiated in the language of CPS, the agencies in California are then directed to go to the next stage, which is to use a structured decision-making risk assessment to inform the individual the individual judgment of the social worker or person making the assessment as to whether to open a case. I have a lot to say about structured decision-making risk assessment. And if you'd like, you can look for a LAAC training on this subject. I believe it's publicly available. But what's important for this context is how the SDM acts as another safeguard for immigrant families who are statistically less likely to score high or very high, which are the scores that are needed to go to the next part of the diagram, which is the opening of a case. Next slide. Here are the 16 questions for an SDM risk assessment for California. CG means caregiver, N means neglect, and A means abuse. Households are scored together on an abuse and neglect index separately. If the number gets over 6 for neglect, you open a case. If it gets over 5 for abuse, it opens. The one sentence description of what's wrong with this is that they are based on actuarial tables of past cases, which were meant to solve the problem of overrepresentation of Black and Native children in the CPS system. But because they were based statistically on the same decisions that they were meant to correct, the 16 questions you see here operate as proxies for race and class. The one sentence description of why this operates as a safeguard against entry by especially recent immigrant families is that these families are statistically unlikely to score in the highlighted categories, which are all categories that implicate US systems involvement, including accessing services to generate mandated reports, interactions with CPS category, criminal legal involvement, diagnosis of disabilities for your children, and then 8, just to explain, is your own history in foster care as a child. Next slide. All of the charges that can be lodged against parents are included in Welfare and Institutions Code 300, A through J. I've bolded the 2 that are most common, which are 300B, neglect, which is a substantial risk of serious harm, and G, abandonment. Currently, neither of these categories is being used in any significant sense to prosecute parents detained by ICE, although in a CPS system that became unfriendly to immigrants, they could be. Because neglect in California does not carry any intent requirement. What that means, if you see the word unable under the neglect part, what that means that if ICE detained a parent with their child present, and then left the child, which is something that was reported to have happened in Los Angeles, this could amount to a serious risk of physical harm that the detained parent was unable to mitigate. Similarly, with abandonment, if a parent were detained and not able to pass on their plan, the child being left behind would technically be without a provision for support. Next slide. If a parent is charged with one section of WIC 300 and their child is removed, this is the court process. I'm not going to go into detail of this diagram, although I've presented it with its criminal analog, because people are more familiar with the criminal system. Keep in mind when you look at this that the person put in the role of criminal here is the child. It is the child who is removed from their community and potentially severed permanently from it. What I want you to see in this diagram is actually how quickly, within 2 years and sometimes less, a child can be separated permanently from their parent. Although in California, indigent parents have counsel, the system runs mostly off of flat fee panels instead of public defense, and it is not very successful in promoting reunification. Across California, you have about a 44% chance of reunifying with your child. Next slide. So to sum, most families will not enter state foster care because deportation alone is insufficient in the code as it is being interpreted now. And were you to get from the mandate, to get a generated mandated report and get to the risk assessment, statistically, you are unlikely to have a high enough risk assessment to warrant opening a case on its own. And the third part, which we didn't discuss at the beginning, is the sanctuary provisions. For children who have entered the foster care system primarily because of deportation, the number one reason for that is in states where law enforcement and ICE have cooperation agreements. Sanctuary provisions in California currently protect families against that. Next slide. And the second part, which is our main point, is that even if these things stopped operating to keep children out of state foster care, we would not want children of deported parents to enter the state foster care system. Again, in California, you have a 44% chance of getting your child back. This is based on data from 2023, where 44% of 80,000, a little bit more than 80,000 children left without reuniting to their parents. If the other issue is the timeline itself is quite fast, parental rights are often severed more than in any other system adjudicating custody. And the adoptions that come out of child welfare are closed adoptions. So you could have, in essence, no idea where your child went. Next slide. So, putting foster care to the side for a minute, what happens if ICE detains a parent who has a minor child in their care? ICE's directives state that they have an affirmative duty to inquire whether or not the person they are detaining is the primary caregiver of a child. They are then supposed to inquire as to your plan and accommodate your custody choices. They are not supposed to take custody of non-detainable children or even travel with them. They are not supposed to put them in their car, for example. If there is no plan or they believe there is abuse or neglect, then they are supposed to call local law enforcement or CPS to take custody of the child. Now, I put some recent cases here just to explain how quickly things are changing, which we'll make a note of at the end. We've seen US citizen children expelled with their parents without an inquiry put to their parents as to the plan. We've seen deporting of non-citizen children with their parent while leaving other children behind who were citizens with no inquiry as to the plan. We've seen children left behind. I think this is actually the largest category. Children left with whoever they're left with no inquiry from the parent or explanation to the person who ends up providing care as to what to do. And finally, the only recent news story that Sharon and I could find about child welfare and ICE actually involves child welfare in Florida reporting a minor to ICE as deportable. So that's the opposite direction of people's fears, which would be that ICE is reporting or inserting children into child welfare. Next slide. And I'm going to pass it on to Sharon.
So we hope that you take away that one of the most important things that folks do is make a plan. It is just so critical for so many reasons to have a very concrete plan for what a family will do if a parent is deported. And I'm going to take a second to pause because I want to acknowledge that what we're talking about is incredibly, incredibly painful. We're asking people to make plans to be separated potentially forever from their children. It's hard for us to talk about. It's hard for us to talk about with clients, and it's unimaginable for clients to have to sit down and make this plan. So we're going to go through a lot of practical tips, but I want to call that out because when you're talking with clients, at least I found that sometimes a plan needs to be made in multiple sessions. Sometimes folks need some time to really gather up because this is just an incredible thing that we're asking folks to do. So the first thing is to think through what the family's goal is. The family's goal should drive their plan. They'll need to have an immediate plan, what happens in the immediate aftermath of a deportation, a short-term plan for what to do in the weeks following a deportation while you're getting together your long-term plan or making it come to fruition. Uh, and what is your long-term plan or goal? So the two sort of big long-term goals that I've heard from families are for the children to return to the country of origin, meet the parent there once they have been deported, or for the children to stay in the United States permanently. But as I said, it's really critical to have a short-term plan, someone to step up in that immediate aftermath of a deportation to care for the child while the family is working towards their long-term plan. Um, We ask folks to think through potential caregivers, um, to think about who could care for your child in the short term and who could care for your child possibly longer term, even if your long-term goal is reunification in your country of origin. It's really important to talk with your children about the plan so they're aware of the plan. And again, I acknowledge that I couldn't that's a very hard thing to do, but it really is critical, especially if a parent is deported while a child is in school or at a daycare. The child needs to be able to tell other adults who to call. It's also very helpful if others around the family, so the school, the daycare provider, neighbors, know the plan as well so that the plan can be implemented, the right person is called. It's very critical, and as I'm doing more cases, I'm realizing how deeply critical it is to gather vital documents in advance. It is really helpful for short and long-term caregivers to have access to school or medical records. It is very important to get certified copies of birth certificates. It is very hard for a non-parent in California to get that certified copy of a birth certificate, which a caregiver could need for many different reasons. It's very important to get passports, especially if the long-term goal is to even visit a parent in the country of origin. It is exceptionally hard for a parent to get a passport when they are out of the country. Passport for their child when they're out of the country. And it's important to have a caregiver's affidavit, even if the long-term plan is for children to reunify in the parent's country of origin. Let me just make sure. Um, we also have seen, and I know you all have seen, ICE take action in public spaces. We would issue a word of warning of taking children to spaces that may be particularly high risk. We would not want a situation where there was a report of a situation in Los Angeles where parents were in a Department of Public Social Services, so a CalFresh or CalFresh office, where ICE came in and detained parents. That would be a really scary thing, and we believe that children there were left with whatever adult was around them who may not know the plan, may not know who to call. And so being really mindful of taking children to situations where a deportation could be a risk. So informal or short-term plans, really, I think everyone needs a caregiver authorization affidavit. What is it? It's a legal form that's somewhat unique to California. It's created by California law. It gives a caregiver, especially a relative, the ability to make educational decisions and most medical decisions. It actually gives a relative caregiver the same ability as a legal guardian in making medical decisions. So it's a really powerful document. A picture of it is right next to the words on your slide. As you can see, it's fairly easy to complete. It doesn't need a court seal. It doesn't need a notary. It doesn't need a parent signature. And it should be sufficient to make most medical decisions if the caregiver is a relative, and many educational decisions. this is something that folks want to have, even if they're, even if it's a short-term plan, because it'll allow the caregiver to do the things they need to do in the immediate aftermath of a deportation. I will call out one limitation. It's kind of a weird limitation. It doesn't give the ability of a caregiver to enroll a child in daycare or preschool. That's an oversight in the law and something at least my office is interested in fixing for the next legislative cycle. We're hoping this legislative cycle, a bill that we're co-sponsoring with the Alliance for Children's Rights, will expand the powers that relatives have under caregiver's affidavit to non-relative extended family members, which are, godparents, neighbors, teachers, mentors, family friends, all kinds of folks that play important roles in children's lives. And so that families have really the ability to lean into their diverse support networks to think about who would be best suited to care for their children. Long-term planning, reuniting in country of origin. This is actually quite complicated. Folks who would like their children to travel to reunite with them in their country of origin need to think about who may travel with the children. Is that person someone who can leave and re-enter? Do they have the ability to cover the cost of that person's flight? What documents will the family need? Passports. And as I said again, and as I'm discovering in cases, it is so critical for folks to get passports while in the United States, although it is possible for a parent to get a passport when only one parent can sign or when a parent is out of the country and the children are in the United States. It is very difficult and time consuming and can prolong separation. Folks should also have a notarized letter, a travel consent document. This will tell the airline that it's okay for the non-parent who is transporting the child to travel with the child. And if there are existing family law orders, so if you have clients who have restraining orders, especially because there likely are child custody orders attached to that, but any kind of child custody case, it is critical that they talk to an attorney. If there are an existing family law orders without something special about that particular case, likely that parent does not have permission to change the child's residence outside the United States without going to court and seeking that permission. So if there are family law orders, if you know folks who have family law orders who are thinking this through, they should proactively talk to a family law attorney about what to do in case of a deportation. For a long-term plan of transferring custody for the children to remain in the United States, probate guardianship is sort of the vehicle for that. It's a legal process that transfers legal custody from a parent to a non-parent. In California, parents and non-parents cannot share custody. There are a lot of benefits to probate guardianships. A probate guardian basically stands in the place of a parent and so can add children to health insurance. They can make all kinds of educational decisions. They can travel with children, but there are some limitations with a probate guardianship. The biggest one that I see is that your parental rights are suspended while the probate guardianship is in place. So it's not you appoint a guardian and they're kind of helping you while you're out of the country. It's your rights as a parent have been suspended, and this other person, the non-parent, the guardian now, is taking your place to make decisions for your child. It can be very, very difficult to reunify with a child if you come back to the country, or if you decide you'd like your child to travel to meet you in your country of origin. Although it's possible if everyone agrees, I've even seen in those cases it taking over a year, even with all parties' agreement, for a parent to reunify. And I've seen many cases where a parent has returned to the United States only to find out that they cannot terminate the guardianship because of the standard. The caregiver has established de facto parent status, and it becomes incredibly hard. I always tell folks this risk in advance, just so they know what they're kind of agreeing to if they nominate a guardian or consent to a guardian, because I've heard so many folks tell me that they didn't realize when they consented to a guardianship that it was quite difficult in California to terminate a guardianship. And I will note that this is very different than other states. In New York and Georgia and Illinois, just states where I've spoken to people who do guardianship work there, it's a very different standard. So folks sometimes get information from attorneys in other states or family members in other states who tell them it's quite easy to terminate. It may be in those states, but it is not in California. So can parents reunify if they return to the US if a guardianship is established? Without a guardianship, if it's just a caregiver's affidavit, which really does give the power to make most decisions for children, a parent can pick the child up from the caregiver without having to go to court. If there has been a guardianship, the parent will need to ask the court to terminate the guardianship, even if the caregiver agrees. And the court will only terminate if they believe that is in the child's best interest. And one of the controlling factors for best interest is where the child has been living and the stability of the child. Um, if the child is living with the other parent, a parent will need to go to court if the other parent does not agree to return the child. So what if my child's other parent does not agree to my plan? If you don't have a family law order and you think the other parent might want custody, you should talk to a family law lawyer right away. If you already have family law orders, like I said earlier, you may need permission to move away, move out of or change the residence of your children out of the country. You can't transfer custody to another person without notifying the other parent. So let's say you've decided that you want somebody to be the guardian of your child. Your child's other parent still has the right to notice of that and still has the right to contest that guardianship or object to that guardianship and say, no, I know that was what the other parent wanted, but I'd rather the child be with me. There's no sort of transferring from one parent to a guardian. And I will pass now to Meredith.
Just want to alert Sharon that there are many questions that have developed over her section um, while I'm doing this. And then hopefully we have time to answer questions for everybody. What if my children are also undocumented? We did cover this a little. Of course, this is one way that children end up in ORR custody. It's still a really good idea to have both an informal and formal plan and to follow the steps that Sharon is outlining. Also, in the handouts that are shared with the group, there are fillable plans for families and also guides that are really helpful. So you don't have to memorize everything we're saying right now or worry too much about that part. What's important is thinking, uh, looking at those guides, but also taking into consideration that these decisions have both short-term and long-term consequences, and that is part of making the plan itself. It's possible that your children can be detained by ICE. Again, I noted a recent story where the siblings were split in a family where the detainable sibling was deported along with the mother, non-detainable sibling left here, no inquiry made about the non-detainable sibling. If they are separated from you, they could be released to a family member, a sponsor, nonprofit, a residential center, or they could end up in ORR custody, which we will talk about just briefly in a little bit more detail. The reason that it's really important to have a plan in these cases and to pay, I see a lot of the questions, and hopefully Sharon can share more widely about the specific travel issues that come up with how to make this plan for travel issues if your child is undocumented. Next slide. This is a very text heavy slide, and I'm sorry, but we had already had it translated, so I left it text heavy. This is the process of getting a child released from ORR to a sponsor. these rules are among the rules that the current administration is changing more or less every other month, to make it more difficult to place with a sponsor, and particularly to make inquiries into the immigration status of anyone who's coming forward. In state foster care in California, the immigration status of someone who's going to act as a resource family, which would be our term for a sponsor, it is not inquired into. And there's, in fact, like affirmative accommodations of how to meet, for example, background requirements if you don't have a state or federal ID. In the federal system, there was analogous assistance previously to be able to just sort of get kids out of the system that is now being circumvented by the current administration. So there is, you have to fill out a sort of lengthy reunification packet. Um, in here is the list. If you go on to, and this is in the resources part of your handouts, there will be Vecina's Reunite project has a free webinar that goes like laboriously through each requirement. Keep in mind that those have been changing every other month, so you do have to check directives and make sure that you're up to date. But they mostly, it stayed the same if the sponsor themselves is a citizen or has lawful status. Next slide. So we just obviously there was a pause to talk about how bad this was for families and how stressful. We wanted to add just one other pause to acknowledge how quickly things are changing. When I talked about the two discourses at the beginning of this talk that were operating for everyone, I wanted to be clear that I think both of those are based in fears, real fears, that the administration has currently embarked on a targeted and aggressive campaign to produce fear for all communities, even tangentially related to immigration. So these changes are happening to what amounts to immigration law nowadays. So if you are watching this webinar taped and it isn't July 9th, keep in mind that there in 2025, keep in mind that there have probably been monthly changes to some of what we've been saying. The other thing that's really important to understand is that the state laws vary greatly. We have tried to focus on California. And the other is that the directives for ICE that we mentioned, I think that sometimes when people, especially people who are not attorneys, hear internal policies or directives, they think of them as rights, but they are not. ICE's internal directive to make an inquiry as to your plan is not conferring a right. There are ways, and there is current litigation over the way that ICE has violated due process, the way that ICE is not following the rules for arrest. For example, when you see a taped arrest and nobody has spoken and someone has just been taken off the street, it's very unlikely that that arrest has met the standards for probable cause that are required for both federal law enforcement and state law enforcement. Those are the sort of things that can be litigated. What we wanted to say, of course, because Sharon and I are heavily involved in both prevention and also fixing problems after families have been separated, is that having a plan, regardless of how the laws change, having a plan is the best way to safeguard your actual family. Like litigation is something you do after something bad has happened. So we are really hoping to emphasize to people the need to do a plan beforehand. And now I think we can turn to questions.
So I see Stacy has her hand raised. I don't know if Stacy, you want to come off mute?
I think hers might be an accident. Are there ones you want
Oh,
to take
okay.
from the chat, Sharon? Or
There are a lot, and some of them are quite difficult, so I'm going to do the best I can. Um, if someone is choosing to self-deport with their 7-year-old, they have a Guatemalan passport, but their child does not, will they be able to stay together through the process? They are accepting deportation at their upcoming order for removal hearing. So it sort of depends on what happens at that upcoming order for removal hearing. If ICE takes them immediately into custody or allows them to make plans on their own. What we have been seeing, and I'm in no way an immigration lawyer, but I believe what we have been seeing is that ICE is not allowing people to make independent travel plans. And so it is quite possible that that person could be detained at that hearing. They should talk to their immigration lawyer about the risk of that. If their child is a has a U.S. citizen, it is critical that they get that passport in case they and their child are separated, because it is possible that it might be difficult for their child to uh, leave separately if they are separated. Let me go down. What is the procedure for a parent who has been deported, remains abroad, to obtain a U.S. passport for a child that has remained in the U.S.? So what I have found is that there is a form, I think it's the DS 5303, that allows a parent, well, it allows both parents to consent to have a third party get the passport for their child. So a parent could get this form, take it to the embassy in their home country, have it filled out, mail it back to the US, and designate somebody else who's allowed to get the passport for their children on behalf of their children. That's if both parents are able to sign. In the case I have right now, mother has sole custody. So she is signing to allow a third party to get the passport for her children and using her custody order to show that she has the ability to consent without the other parent's agreement. There is also a passport form that allows folks to say, I can't find that other parent. Here's the steps I've taken to locate them. And because I have taken all these steps to locate the other parent and can't find them, you should allow me to get a passport without the other parent's signature. My experience is that the passport office is quite strict about that. They want to see that you've really tried to find the other parent and absolutely cannot find them. I have had cases, not recently, but several years ago, where we were able to get a passport with only one parent's signature, but they really ask you to document that you've looked, you've contacted people, you've looked on social media, you've called all phone numbers, showing that you've really tried to find the other parent. Um, How do you get permission from a court to move if you are already in another country? You still file in the United States. So I realize this is a silly answer. I'm going to give it anyway. You already have a family law lawyer in the United States that you've retained, and they are filing the paperwork on your behalf, and they've arranged for a remote service. If not, which is probably almost everybody, you try to find a family law lawyer or you try to fill out the forms in pro per. Um, that is an impossible ask, and I think something that we are thinking about this week, because some of the stuff I'm just kind of realizing are huge problems. Because I didn't realize, how difficult it was for folks to travel until I got a bunch of cases where it was creating self-help materials so people are able to try to navigate the California family law system while outside of the country. Let's see. If one parent was deported and the second will self-deport, what is the best way to prepare? Oop, they're moving. For the worst if the mother is detained while trying to leave. I mean, I think having many different plans is helpful. So having a plan that the mother can travel with the child so you have the passport. Parents generally don't need a travel consent document, but I would have one. LAAC is going to answer that. I'm already halfway through, so I'll finish. And have a backup plan for somebody who may be able to come take custody of the child, at least temporarily, and ideally then travel with the child. So I think having multiple plans and plans that kind of address various scenarios is helpful. Is a written document stating the custody wishes of the parents enough, or will the officers not validate this? It actually does not even need to be in writing, but ideally it should. And we hope they validate it. And I see Meredith off mute if you want to take some of these questions.
I was going to give you a minute by answering
Yeah.
if it hasn't been explained, could you explain what happens to a US citizen child if the parents get removed while together? Will the child be able to stay with other family members or will they go through the foster system? A US citizen child in that scenario is unlikely to enter the state foster care system at all for the reasons that we gave before and cannot enter the ORR custody. If they were to enter the ORR custody, that would be a lawsuit in and of itself. They are not eligible for ORR custody, which is the federal foster care. What we are seeing right now are, I would say, two common scenarios. One is that the child is just being left with whoever they are with physically. So if grandma picks the child up from school, if stepdad picks the child up, whoever was in charge of that child at that moment, it just ends up having the child. And the second thing we are seeing is children being sent, like a smaller number of children being deported, US citizen children being deported with the parent themselves. I think those depend on where the child was when the detentions happened.
So I'll jump in a question about caregiver's affidavit. So a caregiver's affidavit can be used by relatives or non-relatives. Non-relatives can use it. They're just the decision-making power that non-relatives have is much more limited. So a non-relative, and that includes extended relatives. So that includes third cousins and more distant family members. Um, they have the ability to consent to school enrollment and school-based medical. So I would say basic checkups, immunizations. They don't have the ability to consent to more serious medical situations. We are really hoping that our bill resolves this. There is an urgency clause, so if the governor signs it, it will immediately become into effect. So hopefully this becomes a non-issue. We're hoping in late August or September.
So one says, so when detained, do officers ask who they want the child to go with in that moment? What if the undocumented parent is with their child out in public? Do officers drive the child to their desired custody people? Technically, ICE is never supposed to transport children who are not detainable. They're not supposed to have essentially anything to do with them, not transport them, not take them into custody. Um, we've heard people say in the past, before now, that ICE would essentially do something similar to what law enforcement does. Ideally, law enforcement calls a caregiver and waits with the person being arrested for the caregiver to show up. That's sort of the best practice. The same practice was applying to ICE previously. They are supposed to, and there's like a flow chart you can look at that ICE made itself. It's its own flow chart on what they're supposed to do when they detain a parent. And so they are supposed to, if the parent doesn't have a plan or say anything, they're supposed to call local law enforcement or CPS to grab the child. But no, they're not supposed to drive the child to the desired custody people. I hope that answers that. There was one other question. If I know Sharon's looking for good ones in here, but in the caregiver authorization form, I did answer one question about this. Again, it is not notarized, as Sharon made clear. We have seen situations in our CPS prevention work where schools were suspicious of the caregiver authorization form itself. It is an unusual form. We're hoping to sort of up the education level on that, but I do think that you can communicate proactively beforehand about this plan to mitigate a lot of that. And if not, we've had people like actually print out the statute and just attach it so that people can see, even though the caregiver authorization forms that are offered by the state do include a reference to the statute, sometimes it is more helpful to have it printed out. Sharon, back to you.
So I see one. What about deportation at removal hearings? If the child is also undocumented, do they get taken together? Again, I'm not an immigration lawyer. What I've heard from immigration lawyers is it's hard to tell. Some folks are detained together and put into family detention. Some folks aren't. And the last time I spoke to an immigration attorney about this specific issue, they said there's really no rhyme or reason that they can tell for when families are kept together and when they're separated.
I just wanted to say that at the beginning of the PowerPoint is our emails. So for some, I don't want people to panic because there are a lot of questions and quite a few people in this webinar. So please, you're welcome to email us. And if we don't know the answer, then we will find somebody who does know the answer. Um, can a power of attorney be utilized for custody orders to a third party if both parties are in agreement? Sharon, you want this one?
Sure. Powers of attorneys aren't legally valid for the transfer of custody in California. And actually, caregivers affidavits don't transfer custody. In California, the only thing that can transfer custody is a court order. But we strongly advise folks to not use power of attorneys. Most power of attorneys that you see written are actually caregivers affidavit that just have power of attorney kind of slapped on because caregivers affidavits is the legal vehicle in California to sort of give someone else the ability to care for your child temporarily and make those decisions that they may need to make while the child's in that person's care.
There were several questions about whether a caregiver affidavit works for regional center services. I don't know the answer to this. Hopefully, Sharon does.
So it's not explicit in the code. So I would say it does because I would just argue that it does. I would argue that regional center services are under medical decision making. It's certainly not clear that it is, and that might be something that we need to clean up next year, along with the ability to enroll in preschool and daycare. But I would certainly tell folks that they should try using it and let us know if it doesn't. We're trying to set up a phone line so that if folks are having difficulty with caregivers affidavits or with other things, that they can reach out to us so we can track sort of what's happening.
I'm trying to look for one that will take 1 minute to answer. There's one that asks if your organization wants to express support for public counsel's bill, who should we contact?
Yeah, you should contact me. My email will be in the materials. Reach out to me. I'm happy to send you a template support letter. And thank you. We're really excited about this bill and for future cleanup bills so that we can address all the other issues that are going to come up. We really only have 1 minute left.
Yeah, we do.
There's
Thank
so
you.
many great questions. We are going to try to look through these and see which ones we can answer. Some are very specific, and so we may follow up with you personally or have you follow up with us. And some we don't have a good answer for because it's just sort of what depends. It happens in the moment. It's really hard to predict what immigration is going to do right now. And so, I really don't know. I think as we see more cases, we may have a better guess, but I think it's always going to be a guess because they're sort of unpredictable.
Thank you so much, everyone, for coming. Please, again, send us emails with some of these more specific questions, and we will try to address them. I see hands being raised. I don't know how to, if you could unmute yourself, you're welcome to ask a question. Oh, it is one.
It's up to you guys if you want to stay a couple more minutes or just end it off now.
I'm happy to.
Yeah, I can stay.
I don't know how, can people unmute if they raise their hands?
If they raise their hand, I can unmute them.
Okay. Can you unmute someone?
Yeah, looks like Julie is unmuted.
Hi, I'm Julie Rivera-Coon, Neighborhood Legal Services immigration attorney, and then family law experience for over 14 years before that. So my concern is for the caregiver's affidavit for the non-relative, for the best friend who's not related. And so I was thinking about power of attorney. I don't like them either, but for those people, I'm thinking that's the fix right now until the law changes. Or do you have any other recommendations for those people?
I'm going to put a PDF in the chat but I'm also going to say, and then let Sharon take the rest of this one, that in our work, we use power of attorneys sort of as a performance. So sometimes we'll have like a notarized POA knowing that it's not strictly legal because people prefer it, and it looks real. So go
Right.
ahead, Sharon. Let me grab this.
That's the same thing. I mean, like legally, a power of attorney you can't designate those things through a power of attorney. Like there's nothing in the law that says you can do that. And in the law, I think there's some debate about this. We've been debating about this with the Judicial Council. I think you can't. I think it's not legally valid if you do it. I do think people will accept it.
Yeah.
So I also think people will accept a caregiver's affidavit and won't check to make sure that you're a relative. So, you know, I think it's doable for now, and hopefully there will be a fix to the caregiver's affidavit that will address this issue.
Yeah, that's kind of the spot where I see that there might be potential problems with the caregiver's affidavit right now as
Yeah,
it exists.
And if you
I
look
agree.
in
Yeah.
the chat, I put Youth Law did a FAQ on this issue, which is something you could easily give to clients.
Perfect, thank you.
Other people in the chat.
I'll unmute Ruth.
Hi, Ruth Ellis. I'm actually in the education arena. I work with young people to get into teaching, but I also work in the area of special education advocacy. And I didn't catch the whole question around regional center, but I think it kind of made me perk up around the concern around knowing some of the young people I work with and caregiving for individuals with disabilities, especially those that are conserved. I myself am a conservative for a 28-year-old son with Down syndrome. And I think the question around regional center that I have is, in a lot of cases, regional center does take over some level of custody if the parent, God forbid, dies suddenly or whatever. I'm not sure if there's clarity on this yet, and I think it's a very good area to examine because we have a lot of individuals who could be affected by this who might not just even be children. They're just intellectually delayed or disabled adults who need constant care.
Aaron, I hope you have an answer.
I don't have a good answer on that one. Let's take it. We'll take it. I think there's a lot that we're going to take under submission and try to answer because some of these are really difficult and some of them there's just not a good answer to.
Oh, I don't have an answer for that, Ruth, in part because I just haven't seen that in practice yet. So I feel like a lot of what we're seeing is like us trying to follow changes in law rapidly, including like changes in, let's just say, standards of arrest, or we could say not following law for that, which are creating a lot of chaos, which is, I think, probably the intention.
I hear what you're saying. Thank
Sorry, we don't have
you.
a
I
better
know.
one.
I guess this is a community that's marginalized to begin with, and a lot of it flies under the radar. So there is something, I'm on this call, I'm on this webinar because I want to know if I can, as an advocate, provide any support, because a lot of this gets very complicated when the individual has a significant disability, medically, intellectually, social emotionally, and it's a little bit terrifying.
Absolutely. And if you have like a specific case scenario or you're trying to make a plan, please give us a contact. I do think there's an attorney working in family preservation at Disability Rights and Education Defense Fund.
Yes.
I think
Yeah.
together we could help you as like a combined force.
Well, Disability Rights California is doing a lot of work in it too.
Oh,
So,
absolutely.
so I think it's important to have a collaborative conversation around that. Thank you.
Would you like to do one more or leave it at that?
Sure, we could do one more.
Okay, we just have, oh, go ahead.
Oh, no, go ahead. Go ahead.
Okay, we just have Lisa left.
Hi, thank you both for this great presentation. I think it's very timely and important, and we've been doing our own. I'm an immigration practitioner with immigration, U.S. Immigration Law Group, and we've been doing a lot of family preparedness. And I learned a lot from both of you. And I think, I hear what the first person had asked about the power of attorneys. We've kind of been using it as a fixed gap because the caregiver's affidavit doesn't include the people that are most important, I think, to the parent. Generally speaking, in questions with regards to power of attorneys or guardianships, if there is a biological parent that isn't in the picture, I've had people ask if they can use the same paperwork that they've used to have their minor child's U.S. passport be produced as a kind of an exception to having the consent of the other parent. Have you ever heard that being used? And is there an alternative to that single, parent if the other biological parent cannot be found?
So if looking towards like a guardianship route, if the other biological parent can't be found, the person applying for guardianship, so probably the caregiver, can do a declaration of due diligence, all the steps they took to locate the other parent and try to give them notice. There's no excusing notice in a probate guardianship, although courts will sometimes excuse notice for a temporary, but not for a permanent, so not for the final order. But if they really can't find the person, they can do a declaration of due diligence saying, here, I looked for this person. We haven't had contact with them in many years. We don't know where they are. And generally, if the court believes that they made a good faith attempt to find the person to give notice, they'll waive notice.
Thank you.
Yeah, Lynn, do you want us to?
I think that's it for the raised hand. It's up to y'all.
Do you want me to free you? I think Sharon and I are just frantically typing these questions. If we missed any of your questions, please email us, and we will make sure that everything that is sent out to people has. I did see that there were some concerns about the Dropbox, etc. I promise that LAAC can fix that. They're very good at it.
Yeah, LAAC will send out the recording of this webinar within 1 week and the link to the correct Dropbox.
I
Thank
also
you.
see Anne Molina, I think, who had her hand raised maybe the entire time that we said people could be unmuted.
Oh yeah, let me unmute her.
Hi there. Thank you so much. My name is Anne Molina. I'm a housing counselor at LAAC. I was just on here for information, but I did want to first say thank you to you all. And without crying, are there any agencies that you know that are in need of foster parents? I'm a former foster parent. I'm an adoptive parent, and I would love to just know if you have any agencies that are already doing the work of temporary foster care for this population of kiddos.
I know that all the counties are always looking for people for state foster care, although this, as the beginning of the talk makes clear, these children are unlikely to end up in state foster care. For ORR, I haven't seen active calls. I think because the main onus is getting the children to the sponsors themselves. But I do think, Anne, if you're interested in, especially in helping children who are in ORR custody, like it might actually be a good thing to do as a search, because in particular, I think that given our own predictions about how unlikely it is for the state foster care system to take children or take charge of children in mass deportations, and given the way these mass arrests or surprise arrests are happening, I assume that OR custody would expand. So I think looking into that as an individual who's already been cleared through a system would be a great way to help.
Thank you. And then the reason that I had come onto the call today was because I have a same-sex couple that is very concerned about their mixed status family. One child is US born, one child is not. And I think you touched on a couple of the different situations on why the power of attorney might be better than the caregiver affidavit in that situation because they aren't related.
Mm-hmm.
Is that, am I understanding that correctly?
This is
I mean,
Sharon's favorite question.
So legally, no. Legally, power of attorneys have no legal basis for making decisions, for transferring the ability to make decisions. And so theoretically and legally, no, a power of attorney does not give you, but people like power of attorney. So if you take a power of attorney to a doctor, they're not going to know that like legally in California, it has no basis in the law as far as transferring decision-making power to somebody else. So lots of organizations do power of attorneys because, you know, it makes doctors and teachers say yes.
Is it
And
a legal placebo?
kind of, it's sort of like there's the caregiver's affidavit, and that's California's chosen vehicle, and it doesn't do these things we need it to do. So we kind of made up this other thing, but we might as well legally have written it on a napkin. But it looks fancy, so people who don't know any better accept it. And so legal placebo maybe, but it's right now, I think it's working. And so until the law changes, I'm not going to say do it because I know that it has no basis in the law, but I know that people have done it and gotten what they needed.
Oh, also,
So maybe both?
Maybe.
I would say we've had situations where we were doing prevention of a child entering state foster care for somebody who was pregnant and incarcerated, where the jail itself would not accept the caregiver authorization affidavit, or accept sort of a declaration that the person would be filing in probate. Like they literally would accept nothing but a power of attorney. So there are cases in which like bureaucracies are preferring this as well, and in which case there's nothing you can do but fill out a power of attorney, which is what we did in that case, even though it has no legal validity. Does that make sense?
Yes, definitely. Definitely. I just, it's a little harder to translate that.
Yes. Yes, it's just like an absurd thing that's been happening because we don't have a standby guardianship that makes sense for short-term decision making. So we've put parents in a real bind, which is part of what I think Sharon was explaining with the long-term consequences of something like probate, which is fairly easy to get, versus there being short-term options that have serious limitations like the caregiver authorization affidavit.
Got it. Thank you so much. I so appreciate it.
Thank you. Thank you, everybody.